I'm Joe Schmidt. I'm a management side labor and employment attorney at the Nyland Johnson Lewis law firm, and I have a subspecialty in the pay equity area. One of the Trump administration's first regulatory changes after it entered into office was to cancel the Equal Employment Opportunity Commission's directive to gather pay equity information from larger United States employers. On August 29th of 2017, acting EEOC Chair Victoria Lipnick announced that the EEOC's prior effort to collect information would be canceled. However, the United States District Court for the District of Columbia recently announced that it would be overturning that EEOC decision and instead reinstating the EEOC's requirement that employers over 100 employees and federal contractors with more than 50 employees must provide pay equity information to the EEOC, but now on a more accelerated schedule. There are two sets of information that employers need to produce to the EEOC. The first set, called Component 1, needs to be produced to the EEOC by May 31st of 2019. This set of information seeks data regarding the employees working for the employer and their race, ethnicity, gender, and other characteristics. Employers may seek an extension to provide this information, but only a 2-week extension until June 14th of 2019. The second set of data is called Component 2 data. Employers must submit this Component 2 data to the EEOC by September 30 of 2019. The Component 2 information requires the employer to submit information regarding a pay period in 2017 and disclose the hours worked and compensation for all of their employees broken down by 12 job categories to the EEOC. The employer must also submit a similar set of information for a pay period in 2018. The employers may choose the pay period in question so long as they select a pay period for the year at issue between September 30th of that year and December 31st of that year. Employers should assume that the EEOC will make use of this information. The EEOC can launch a directed investigation of employers based upon pay equity data, such as that employers must disclose to the EEOC in Component 2. In addition, the EEOC may examine that data for existing EEOC charges. It would be prudent for employers, before producing the data to the EEOC, to do their own pay equity audit to examine whether that data discloses any problems that the EEOC might focus on. In addition, of course, if there are problems identified by the employer should take remedial steps to address those issues and to address any pay inequities that may exist so as to forestall EEOC investigations and other pay equity liability.